The topics for this afternoon are going to be taxes and debt, and we are pleased to kick off this afternoon of the conference with a discussion specifically about consumer debt and consumer debt default judgments. So to kick things off, we'll just go down the line and introduce ourselves, everybody who's up here on the panel. To start, my name is Caitlin Wolf, and I serve as the Uniform Law Commission's Legislative Program Director. I'm based in Chicago, and it has been my pleasure working with the folks up on this panel to put together the ULC's Uniform Consumer Debt Default Judgments Act, which we'll talk more about a little later on in the panel. But for now, I'll turn it over to Judith Fox for her introduction.
Hi, my name is Judith Fox, and I am a recently retired professor of law from Notre Dame Law School, where for 25 years I ran the Economic Justice Project, and I am the reporter for what is now called the Consumer Debt Default Judgments Act. And I say that because if you've been following us at all, we changed our name last week. So it's the same act. We just decided to make the name fit the act a little more closely.
Good afternoon. My name is David Reid, and I'm General Counsel at the Receivables Management Association International. I've been there for 12 years now. Among the things I am responsible for is government affairs for all 50 states. So turn it over to Erica.
Hi, folks. I'm Erica Rickard. I direct a project at the Pew Charitable Trusts that is focused on modernizing our state courts. We've been doing research about debt collection lawsuits and contributing some research to the Uniform Law Commission.
All right, well, thank you. And thank you all for accepting my invitation to be part of the panel today. So to kick things off, we do understand, not everybody in the audience may be familiar with these types of lawsuits, with consumer debt, with what we're talking about. So to start things off, I'm going to toss it over to Erica to give us a sense of what findings your project has, conclusions you've come to over the last several years. Give us a sense of what these consumer debt lawsuits look like now.
Great, and we actually have slides for you, so we'll use some of the data points along with these slides. So just to lay a little bit of foundation, what we're talking about today, debt collection lawsuits are generally lawsuits brought by original creditors, debt buyers, or healthcare providers that are brought against consumers for money, unpaid debts. And these are a growing number of civil court cases today. So this data that we have from 1993 to 2013 shows this doubling from less than 2 million debt collection lawsuits to over 4 million, around a quarter of all civil court cases. And we actually have some data from 2016 to now, which we don't have available for prime time yet, that shows that an increase, another uptick in debt collection lawsuits, showing that basically in states across the country, debt collection lawsuits represent the single most common type of civil court case. So what happens in these kinds of court cases, as Caitlin was asking? Next slide, please. When we think about civil courts, we think about two sides, each having an attorney in a courtroom, arguing the facts of their case in front of a judge and sometimes a jury, rendering a decision based on those facts. That is not what happens in a debt collection lawsuit. In a debt collection lawsuit, you'll have maybe a judge or another judicial officer or a magistrate, and then you'll have an attorney representing one plaintiff or maybe multiple plaintiffs. And then on the other side, you have a consumer without a lawyer, or more often, an empty chair. So I'll take those two things in turn. Next slide, please. First, on representation. What we see in debt collection cases is that you do not have a right to an attorney, unlike in many criminal court cases. So if you cannot afford one, one is not provided to you. And indeed, in debt collection cases, plaintiffs are represented nearly 100% of the time, whereas defendants have lawyers less than 5% of the time. So that's the representation asymmetry that we see. On the next point, the empty chair. Next slide, please. What happens in these cases most often is that consumers do not participate in the case. So in the states where we've looked at data, more than 70% of cases end in what's called a default judgment, meaning that the consumer either did not file an answer or did not show up to court. And what happens then is the judge does not step into the shoes of the defendant and look to see if the right person was sued for the right amount in a timely manner. What happens instead is what's called a default judgment, an automatic or default win for the plaintiff, based not on the merits, but based on who actually participated in the court case. A default judgment carries with it the same weight as any other court judgment. So that includes post-judgment collection actions like wage garnishment, asset seizure, and in some cases, civil arrest warrants. But it's not based on the facts of the case, it's based on who is participating. So that's the landscape that we're working in. We're working in a situation where in states that we've looked at, anywhere from 1/4 to 1/3 of the civil docket is a debt collection lawsuit. And in a vast majority of those cases, only one side is participating. That's true across the country. And it's been under the radar for a long time, but in recent years, we're starting to see court leaders and other leaders starting to take notice of this and think about how is that connected to the way that we expect our court system to work, that we expect the justice system to work. And even recently, just before the pandemic, the Conference of Chief Justices and Conference of State Court Administrators, which is this national body that brings together the court leaders from all across the country, put out a resolution calling for states to do something to address this high number of default judgments in debt collection cases. So next slide, please. We are starting to see some movement in that direction. And I'm going to talk about 3 different trends that we're observing when it comes to both court rules and state statutes that are trying to increase consumer participation and decrease the rate of default judgments in debt collection cases. Next slide. So when we're thinking about why people don't participate, there's a lot of reasons why a consumer might not participate in a debt collection case, some of which is completely outside of the court's control, some of which is within the court's control. So we're starting to see court rules and statutes that are trying to tackle some of that issue, namely when people don't know that they've been sued, when they don't understand who's suing them or why, or when they're not sure what to do next. So this first set is we're starting to see some changes to make sure that consumers know that they've been sued and to know what the debt is from. So the naming the original creditor on the complaint, or providing more information about the original debt to provide some information to that consumer, as well as making the information a little bit more plain language, straightforward, and clear for people to know that they've been sued in the first place. Next slide, please. The second set of things that we're seeing is recognizing that such a vast majority of these cases have an unrepresented person in them, both simplifying the process and then clearly communicating that process to all the parties in the case. Make sure that you know what to do next and that what you have to do next makes sense. And the next slide, the last trend that we're seeing is less about consumer participation and more about court participation. So as I said at the beginning, judges typically don't step into the shoes of the defendant to argue that side of the case, right? But what they can do, and what they're starting to do in a handful of states, is review the case at the outset for its validity to see if the claim on its face is valid, if there's documents supporting that claim. So what you can see in this slide is a map that's mostly gray, which means we haven't done a 50-state set of research yet, and the states that we have seen a change toward increasing the review and the responsibility on the court to review the validity of the debt are only the states that are in green or yellow. So it's not very many. And I think what we'll be talking about throughout the rest of the panel is this is a situation where the same problems plague consumers and courts around the country, but the policies in place are a real patchwork that really depends on where you live. So this is really crying out for some clear and consistent policies around the country. And with that, I'm going to turn things over to David.
Thank you. Next slide. All right. So the Receivables Management Association International, we are a nonprofit trade association. We have over 620 members nationwide in all 50 states. Very diverse membership. We have banks, credit unions, non-bank lenders, debt buying companies, collection agencies, collection law firms, vendors, brokers, really runs the gambit. We were founded in 1997 to be the voice of the receivables secondary market, which is debt buying companies. Our scope obviously has grown much since 1997. The Receivables Management Certification Program, which I will be talking a little bit about in some upcoming slides, kind of sets the global standard, if you will, for our industry within the receivable space. Next slide, please. All right. So RMAI is in broad agreement with the comments that were made by Erica, as well as the comments that will be coming forth with the Uniform Law Commission in the discussion of the Model Act. But we agree 100% with Chair Trust that there are too many default judgments out there. And one of the questions, and Erica touched on it, is what's causing these default judgments? There are many reasons, including the ones that Erica had mentioned. And there are some people who, I suppose cynically, feel that companies, the business community likes default judgments because the consumer isn't present for it. And I'm not, there are many different types of business practices, by the way, within the receivables industry. But what we see from our members, because we survey our members, we obviously have conversation with our members, and these are, questions that I personally ask our members all the time, and we've done surveys of our members trying to get to the base of it. What is driving these high numbers in default judgments? And what we find from these surveys, and again, I don't want to speak in absolute terms, but generally what we find is that our members feel the reasons why the default judgments are so high is because the consumer knows they owe the debt. And the situation being that, bad things happen to good people all the time. I mean, I think we all recognize that the vast majority of individuals, when they take out a line of credit, they take it with the full intention to make payments and to pay it off. But then what happens? Life happens. There's an unplanned illness, a job loss of a spouse. There are many things that could happen that could derail someone from payment. A global pandemic. We didn't know that one was coming until it happened. And so when a consumer has defaulted on a loan, by the time they get to the default stage, they've already received many phone calls and contacts from the originating creditor. And some originating creditors do collections in-house, so they get a number of calls from the collections department within the originating creditor. And then most business models, they transition to a third-party collection agency. So then they get calls from a third-party collection agency and email, if they potentially have email, but also mail as well. And by the time it gets to litigation, they have had so many different contacts that the consumer, in a way, you have to put yourself in their shoes. I mean, they're probably depressed. They feel frustrated. They feel hopelessness because they're like, I'd pay it if I could. I just can't. And then they get a summons to show up at court. And many of them, again, from what we can tell, kind of feel like throw up their hands in the air and go, well, for what purpose? I'm going to go to court to be told that I owe a debt that I already know that I owe. And I'm going to take time off from my job to do that. I'm going to have to get childcare to do that. So they just don't go. And the default judgment is issued. And again, I don't want to say that that's a universal example, but at least from the business community, from what we've been able to survey and get responses, that seems to be the feeling that that's probably a majority of the cases. But certainly some of the other explanations are potentially valid as well, that Erica mentioned. And I would just note, and it's interesting, the pandemic did teach us something that was interesting. At the start of the pandemic, in probably 2020, 2021, when there was very little individuals stepping out, especially into the courts, they did a lot of this remotely. And what we did find is we surveyed this too. We were curious with all of the virtual attendance of court, did that have an impact? And it did. Attendance was higher from the consumer side with the use of technology than when they were required to appear in person, physically in person, I should say, rather than in person virtually. So, and the numbers as we've gone back to the courts have started to, the default judgments have been increasing again, because the attendance has dropped. So perhaps something positive can come out of the pandemic, that we can learn that maybe there are other innovative models that help the consumer at least address some of their issues, like transportation or childcare, and maybe virtual isn't a potential option. Let's see. And then as for RMAI also agrees with the goals of the Uniform Law Commission. You know, the bottom line is, I mean, I deal with all 50 states, and then it sounds more dramatic than it actually is. Usually there's only like 7 states in play in any given year, so it's not like I'm running around to all 50 states. But for a trade association standpoint, we like uniformity. You know, to have 50 different laws in 50 different states that say something slightly different from the others is a complete nightmare for the business community, because it creates opportunity to accidentally slip up because there's so divergent, you know, little nuances between all the laws. So the 11, 12 states, give or take, that have been adopted laws so far, which RMAI has been involved in all of those negotiations, and we've generally been supportive of all of the laws that have been adopted. You know, our goal when we go in, my #1 goal is to try to create that uniformity, and we look at, you know, a template of one that was been adopted. Usually it tends to be the California law, and we try to use that as the model, if you will, at least until Uniform Law. But ultimately, you know, from our standpoint, the laws that have been adopted in the Uniform Act, you know, we need to make sure that we have the right person, the right amount, and quite frankly, that you have the right person who has standing to bring suit. Next slide. So RMAI's certification program, we launched our certification program in 2013. It was actually came about through the strong encouragement of both the CFPB and the Federal Trade Commission in conversations we had with them back in 2011, it would have been. The CFPB had just been stood up as an agency. And they strongly encouraged that the industry look to develop some type of self-regulatory program. Obviously not in place of them, they were still going to regulate us, but they thought our industry really could benefit from having a self-regulatory program. So that's what we developed. And you know, our mission statement's very short, so I'll just read it. The RMAI Receivables Management Certification Program is an industry self-regulatory program administered by RMAI that is designed to provide enhanced consumer protections through rigorous and uniform industry standards of best practice. And I know sometimes folks say, really, why would the industry care so much about consumer protection? Well, first of all, the right thing to do, but secondly, consumer protection and ensuring that business community is doing everything to protect the consumer as possible helps to weed out bad actors. I'm not Pollyannish. I know there are bad actors out there. And all of the business community who's trying to comply with all of the state and federal laws and regulations every single day and spending a lot of money on compliance, it's really all for naught if you have this rogue actor that comes in and does something that makes the front page of the New York Times. And so, you know, our goal obviously is to have a rigorous program that that reduces that type of risk for the industry as a whole. Next slide. So our certification program, as I mentioned, was adopted in 2013. It launched in 2013. We spent a year developing it. So we just celebrate our 10-year anniversary of the program. And so the types of receivables we certify, both consumer and commercial was just added in version 11.0 of the programs just this month. But consumer has been always part of the program. We have 63 program standards, certification eligibility, collection agencies, collection law firms, debt buying companies, vendors, process servers, brokers. They are all able to be certified, and they have standards specifically for their type of operations as well. Asset classes. Well, the program when we launched was just credit cards, but we realized quickly that when you have specific asset class, well, actually, I would say, let me back up. The original standards were designed for all debt, but they were really modeled after credit cards. And what we realized with other asset classes, it was a little bit of a square peg round hole, because the data and documents you need to prove a debt when it's credit card is different than if it's auto. It's different than if it's fintech. It's different if it's judgments. It's different if it's student loans or medical. So we realized that we need to diversify the standards that specifically as it relates to data and documents so that it fits for different asset classes. And that's how we've broken out the program. Currently, we have 464 active certifications within the program. Next slide. All right, I don't expect you to be able to read that. That's more for, I guess, a visual. But these are our standards, our data and document standards, just for credit cards. There's 3 columns. The first just describes the asset class. The second is the required data and documents that we require our certified companies to obtain when obtaining or when purchasing an asset or a defaulted portfolio of receivables. And then the second one is commercially reasonable efforts. So commercially reasonable efforts, you need to try to get those data and documents, but you can still buy them as long as you have the required data and documents. So there are 14 data and document requirements under the required and 10 under the commercially reasonable efforts. These were modeled after, by the way, the CFPB and the Office of Controller of the Currency, so the OCC. I would say that of the required, 9 of the 14 elements on the required came from the CFPB, and then 8 of the 14 elements came from the OCC, and they didn't line up, obviously. And then on the right-hand column, commercially reasonable efforts, none of them came from the CFPB or OCC. So we really do feel that these are the gold standard when it comes to what type of data and documents you need to have when purchasing, and as well as if you're going to sell, provide the exact the same as well. Next slide, please. And I would just say that that graph, we have one for each of the asset classes. That was just the credit cards. So, you know, obviously we have these standards, but the standards are only as good as compliance. And how do we tell compliance? We have independent third-party audits. Well, we have 4 different types of audits. We have a pre-certification audit that's done by an independent third-party auditor. We have a self-compliance audit that's part of the application. We have a full compliance audit, which is done on a regular interval, and that's done by an independent third-party auditor as well. And then we have a limited compliance audit, and that's a limited compliance audit is something that we would do as an association if we think one of our members is out of compliance on a particular standard. And you know, so what we've realized as the program has evolved is that a number of originating creditors are now requiring our RMAI standards, and they're requiring the collection agencies or debt buyers that are working with RMAI to adhere to these standards. Although we can't require it, obviously, because of antitrust reasons. And my final slide is, well, you know, so when we developed the program, we thought we were doing something unique. We thought we were doing something that would make a difference, but quite frankly, we didn't know. You know, we realized we had to wait for statistics to be able to tell. And so this was our first dive at looking at the impact of the certification program. It was done in 2019, so we're actually in the process of updating it. I haven't gotten the statistics back, but just wanted to say these are 2019 statistics. But we looked at the 3 federal acts that have a private right of action to be able to judge, you know, how our program was working: the Fair Debt Collection Practices Act, the Fair Credit Reporting Act, and the Telephone Consumer Protection Act. And we looked at RMAI certified businesses and then compared it to companies that were not RMAI certified within the financial services space. And we looked at the litigation by the consumers against those certified and uncertified businesses to see how they compared. And what we found was over a 7-year time horizon from 2013 to 2019. And what we found for the industry is in blue, RMAI certified businesses in green, what we found across the board is that litigation against RMA certified businesses was declining, and with the exception of the FDCPA, for the industry as a whole, it was increasing. So for the FDCPA, for the industry, it was down 3.5%. For RMAI certified businesses, it was down 20.2%, 16% delta. For the FCRA, industry as a whole, it was up 13.5%. RMAI certified businesses, it was down 18%. That's a 31% delta. And then finally, the TCPA, for the industry as a whole, it was up 26.7%. For RMAI certified businesses, it was down 19.3 or 46% delta. And when I got those numbers, I had the demographer go back and run them again because it didn't seem right. And I said, double check those numbers. And she came back and she said, no, they were right. So we're very proud of our program. Is it perfect? No. You know, we're always trying to make it better. In fact, every year, the reason why we're on version 11.0 is because there's a requirement that we enhance the program every year. So, I'll turn it over to Sheila.
All right. Thanks, David. So earlier, both Erica and David, I think you mentioned a little bit about just the current patchwork, really, of state laws with respect to consumer debt collection, to default judgments. There is certainly not a uniform standard, but that is where this Uniform Law Commission project comes in. So a little bit of background I'm going to explain about my organization, the Uniform Law Commission, our drafting process, and sort of the way in which this Uniform Act has started to come together before I turn it over to Judy to do a walkthrough of the Act. So first and foremost, the Uniform Law Commission that's been working on developing this uniform state legislation on the topic. It's a nonprofit national organization. It's been around since 1892, and it actually originally grew out of a committee of the American Bar Association. So its mission is to draft state statutory law in areas in which uniformity across the states is both desirable and practical. So you can think a lot of issues where there's interstate borders, folks moving state to state. We do work across a number of different issue areas, everything from business entity legislation to family law legislation and so on. The members of the ULC, who we call our commissioners, they are all attorneys. They are appointed by their state governments to serve the unpaid role as volunteer commissioners for the organization. So they donate their time and expertise to drafting uniform state acts. And we have commissioners who serve in all sorts of positions. We have folks who are chief justices of their state Supreme Courts, law professors, folks in private practice, people who work in legislative drafting agencies in their state capitals, and in a number of other roles. The work of the ULC is financed by mostly state appropriations. We also get royalties from publishing the Uniform Commercial Code, which is one of our hallmark products. So any attorneys in the room, I'm sorry, contracts class was all about us. And then we also have a 501c3 foundation arm as well. So a little bit of background about sort of how the organization works, how a uniform act like the one we're going to talk about comes together. So first is we have to have an idea, right? So the ideas for uniform acts can come from any source. So law professors, members of the public, stakeholder, I mean, really they come from anywhere. Anyone can submit an idea to the ULC. That idea goes to what we call our scope and program committee, which is sort of the gatekeeping committee of the ULC. It's the first body of commissioners to sort of take a crack at it and try to understand whether or not this idea could reasonably translate into state legislation. And then if they do think that this idea is worth pursuing, the ULC will form a study committee on the topic. A study committee is composed of commissioners. We also invite outside experts and stakeholders to participate with us in the entire process. And a study committee will typically work on the issue, research, convene over the course of about a year. At that point, they need to make a recommendation to our leadership on whether or not, after this extensive study, do we think there's a there? Do we think that this is an idea that should actually be drafted into a uniform piece of state legislation? And if so, then the Uniform Act will go to what we call the drafting phase. And that's actually what we're in right now with this Uniform Act. So we're nearing the end of the drafting phase. The drafting committee meets in person, usually a couple of times per year. With the pandemic, we've done a lot of work, of course, over Zoom as well, or in a hybrid format. And if you could do the next slide for me, Allie, thanks. We've sort of managed to find our way. Again, we've been around since 1892, so a global pandemic wasn't going to slow us down over the last couple of years, finding a way to get this stuff done. And then we also have a formal process by which every uniform act that's developed is read aloud to the entire body of uniform law commissioners, some 300-400 attorneys, and they almost have like a mini House of Representatives debate about it. Everybody stands up at microphones and makes motions and gets to amend and change these uniform acts as they're being developed. So that's a little bit about the process. Next slide, please. There are also, as I mentioned earlier, numerous opportunities, endless opportunities for public participation in the process. I'm particularly thrilled that with respect to this project, we've had the expertise of folks like Erica, like David, like so many others who have kept pace with what's going on out there. What are the needs of the court systems, of litigants, of all of the parties, all of the pieces of the puzzle for these cases? So anyone is welcome to participate and to follow along with any of the ULC's drafting process. Or any projects. The easiest way to do that and to get a sense of what we're working on is to go to our website, which is uniformlaws.org. And anyone can sign up to participate in meetings, offer their own comments and participate in that way. Next slide, please. So this sort of begs the question, so why is this act in particular being developed? And as David and Erica mentioned a little bit earlier, the current patchwork of state laws, I mean, it's just all over the place. You saw in Erica's map that, we don't even have really accurate information as to what's going on in so many states, all those grayed in states on the map. So we're trying to move forward in a way that will allow us to, we have identified a number of problems. So what we're trying to do with the Uniform Act is to come up with sensible solutions to those problems that could actually be enacted and practically adopted on the state level. So just to go through a little bit more timeline, in 2010, the FTC recommended improvements to state and federal law with respect to consumers getting adequate notice about debt collection claims. Wanted to require more information in complaints and ensure compliance with statutes of limitations. And then, as was mentioned earlier, in 2019, the Conference of State Chief Justices had their own resolution, again, recommending that plaintiffs in debt collection cases file documentation explaining, I do have a legal entitlement to the amounts they seek before entry of judgment against the debtor. And then finally, in 2010, the National Center for State Courts found that these, state measures have resulted in uneven justice because there's such a patchwork going on right now. And the National Center for State Courts recommended uniform reforms, uniform solutions to these problems that every state is facing in some capacity or another. So that's why the ULC opted to get involved here. Next slide. I don't know how well everybody can read this, but again, there is quite a disparity when you start to look and compare one state's laws to another in this issue area. So first of all, a minority of states even have law or rules on this topic that govern the award of consumer default judgments and the procedures that one needs to follow in those states just vary widely. So 11 states do have law or court rules that address claims filed by debt buyers. 3 states exclude claims that are filed by financial institutions. 2 states address only revolving credit. 2 states cover only credit card debt. 2 states deal with small claims court only, and so on and so forth. So again, there's no one size fits all, one clear template as to what states should be doing and how best to handle these sorts of cases. Next slide. So in terms of objectives and goals with this Uniform Act that we're developing, Judy's going to go into more of the mechanics of the act, but an overall 30,000 foot view, some of our key objectives are to establish pleading requirements that will cause creditors to screen out defective claims in the first place. A huge one is just transparency and meeting these consumers where they're at, explaining to them, prompting access to information, telling them that there are defenses potentially available to them and encouraging the voluntary resolution of claims, informing consumers about potentially adverse consequences. What could happen if you don't show up in court? And identifying legal aid organizations that may be able to help them defend themselves in such an action. Also bringing courts in, providing courts access to information that they need in order to fairly and efficiently evaluate these claims for default judgments, and then increase the availability and lower the cost of credit by promoting efficient debt collection practices as well. Next slide, please. So I did mention this earlier that we are sort of nearing the end of the drafting process for this particular Uniform Act. So the act was read, according to our ULC protocols. We read it aloud. We offer debate and discussion on the act at least 2 of our annual meetings, which occur every summer in July. So last summer, this act was read and debated by our body. We've had a couple of drafting meetings since and made more changes to the act. And then the plan is that this act will be finalized in July of this year after another debate and reading and taking comments from commissioners at that time. You can view an updated copy of the Uniform Act, sort of where we are right now with this document, on uniformlaws.org, our website. And then in terms of timeline going forward, we hope that the final piece of legislation will be available in October or November of this year, and that we can pursue enactment of it in the states as early as next legislative session. So with that, I'm going to turn it over to Judy to go more into the weeds about what is in the Uniform Act and how it operates. So thank you, Judy.
Hi. So just to bring us back for a minute, some of you may be sitting out there saying, so what does this have to do with economic justice? Well, what we know and what many, many studies have shown is that most of these default judgments are entered against members of minority communities and low-income folks. So this issue of default judgment is very much disproportionately affecting those communities. And hopefully, when we get the resources up for this conference, we're going to provide some of those studies for you if you want to take a look at those studies. But it's pretty well documented across the country that these default judgments are having an adverse effect. And oftentimes, having represented consumers for 25 years doing these, people don't realize they have a judgment against them until somebody garnishes their wages. And if you want to make somebody in poverty, who wasn't in poverty or who in poverty in real crisis, they get their wages garnishment and suddenly they've tipped over the edge and they're in trouble. So one of the main purposes of this act was to try to inform consumers upfront. And, as David mentioned, the industry believes that most people know they have the debt. And I would say that some people do. But most of the people I represented didn't know who was suing them or never got service because they had moved, or frankly, it wasn't even them. Now, hopefully, or they get this piece of paper and one of the common complaints forms we used to see because we have noticed pleading was, you are being sued on a credit card / car loan / installment loan / whatever, without telling the person what it was. And people are confused enough and stressed out enough, and they're just like, well, this isn't me, forget it, and they ignore it. So one of the first purposes is to give them more information so they can say, hey, wow, this is my debt. Maybe I want to call up and do something about it. Or, hey, this is not my debt. Maybe I want to show up and do something about it. The next, so we're trying to encourage participation because, as David said, it doesn't really do anybody any good to have default judgment, right? creditors would like to get their money, which they may never get if there's a default judgment, and the consumers might have a reason to contest the amount, or might even be able to make a settlement for a smaller amount. But the other purpose of this act is to give information to the courts, because what we were hearing from the state courts, and again, a lot of research that was done, is that kind of a robo process, to use an old term from my days doing foreclosures, where the courts have high volume of these. They just issue judgments because nobody showed up, and many judges were uncomfortable with this. I don't know if this person's really entitled to judge, because contrary to belief, and I hope there's law students out in this audience, just because someone doesn't show up or answer, you might be entitled to a judgment on the liability, but it doesn't necessarily mean you're entitled to the amount of money you're asking for, right? And so some of the judges were saying, hey, I'm not sure that this is even right, and there's not enough information in this complaint for me to even say it. So the courts wanted more information. So one of the things we're trying to do is give the courts more information so they can look at this complaint and say, okay, yeah, this is legitimate. I'm comfortable issuing this judgment. And then finally, as David was pointing out, we want to give the plaintiffs some clear guidance, because this has become more and more of a national business. And when you're operating in 5 states or 6 states or 50 states, it's very hard to keep all the rules straight. So we're not trying to trick debt collectors into making mistakes. We want everybody to do everything that's correct so that this moves forward. So the idea is to have uniform rules that everybody can understand, that are fair, so that the debt collectors don't accidentally make mistakes. Because again, we're not trying to generate liability here. We're trying to prevent it. I do want to make the point that this is not a state FTCPA Act, which is the Fair Debt Collection Practices Act. And there have been observers out there who have been confused about that. This is totally separate and different from that. The FDCPA covers, there's a little bit of overlap here, but this is not meant to be that. So next slide, please. So what's the scope of the act? So our act would cover any unsecured consumer debt. Now, we're using the consumer definition that's used across the industry and many other federal statutes, which is basically any debt that was used for household or family personal use, right? Secured debts, to the extent if you're only asking for money. So let's suppose you had a car loan and they repossessed the car, and now they're just suing you on what they claim you still owe on the loan, right? Or more commonly, well, let's use car loans. That's a very common one, right? So if the lawsuit is only about collecting money and not about gaining possession of that asset, it would be covered. Deficiency judgments, which again, the reason I stopped and said, I don't want to talk about car loans because they're related. But suppose that you can't do this in all states, but we saw a lot of this in Indiana after the last foreclosure crisis. Somebody, the house is repossessed, right? But they don't ever pursue a deficiency, and somebody then sues you on the deficiency. The difference between what was secured and what wasn't secured. As long as it's just about that amount that they're suing you on, it would be covered under this act. And the reason it says not possessor or repossession action is because there was a lot of debate about whether we should include landlord-tenant debt. And I want to thank all of our many observers for weighing in on this, that this would cover landlord-tenant debt in the way if somebody is suing you just for back rent or fees or whatever, not to evict you. And the reason we wanted to include that is there is a growing trend across the country of landlords not pursuing damages in court, just sending those to collection agencies. And there's a lot of now activity, and a lot of this is what the FTC is now calling junk fees and things, but there seems to be a growing amount of litigation related to housing debt that we want to make sure we include, but that's not involved in the actual eviction, right? So if a landlord brings a case against you to evict you and collect rent, it wouldn't be covered by this act, but if they just bring a case against you for the rent, it would be. Next slide, please. So what this act seeks to do is prevent default judgment. So the sort of hallmark across the, in fact, we had it written in there 3 times. It's now only written in there once, but what this act says is that a court cannot enter or may not enter a default judgment against a defendant unless the plaintiff has complied with the act. I joke because I said cannot and then I said may not because there's a big debate in the Uniform Law Commission about using the word cannot, and we have to say may not, and I don't like that, but I'm following the rules. And my editorial comments are my own, not the Uniform Law Commission. Next slide. So the Act sets out complaint requirements, things that have to be in the complaint if you want a default judgment. So the first piece of that is information about the consumer themselves. So you have to set out their name and address and any other names and addresses they've used that are in your records. Now, why do we care about this? Well, as I said before, I have represented people who, John F. Smith owned the debt and John K. Smith is being sued. And if the complaint says this is John K. Smith, John F. Smith, who gets the complaint, can say, hey, that's not me, right? But also other names and addresses. So you may be suing, my maiden name was Casca, right? You may be suing Judy Casca. And I was like, well, that's not me anymore. And I never had a loan in that name and that's a different person, right? So if the person, now, going back to the commercially reasonableness that David brought up, we aren't asking the plaintiffs to search the world to try to find these things. We're saying if you've got this information in your records, you should include it in the complaint so the consumer knows who they are. Next slide. Then the next sort of threshold that we're looking for is information about the creditor. So we're asking the creditor to identify themselves, but not just their name, but any affinity name, merchant brand, facility name. What does that mean? Well, now that Sears kind of doesn't exist, this doesn't happen as much, but one of the most common debt cases that I used to get when I was representing folks is people being sued by Citibank and them saying, well, I never had a loan with Citibank, but they had a Sears credit card. And Sears credit card is who, ran through Citibank, right? So the idea is that we want the creditor to identify themselves in a way that the consumer would recognize it. So, you could say Citibank, Sears credit card, right? Or Memorial Hospital, right? But I'm not, because oftentimes you've got a debt collector's name as the plaintiff, and the consumer's like, I never heard of that person. I never had a loan with that person. So this would be to identify them so that they would know who is in fact suing them. And they might be able to then say, oh yeah, actually this is my debt. Which every time I had one of those Citibank Sears cards, it really was their debt. They just didn't recognize it, right? So next slide, please. And then very importantly, we want them to contain information about the debt itself, right? So the last 4 digits of the account number, if there is an account number, if there's not an account number, invoice number, something like that, so that the consumer can say, okay, yeah, I had that credit card. A date and an amount of the last payment. And this has 2 purposes, right? A debt may have been sold from debt collector to debt collector to debt collector, and you may have made a payment on it last year. And then you get sued and it says the last payment they got was 2 years ago. It may well be that you haven't gotten credit for a payment, right? And so this is sort of to give the consumer information. It also might help you remember, like you say this isn't yours, but we're showing you made a payment on this debt, such and such a date. And then you go back and you look like, oh yeah, that is mine. I did make that payment. Date of charge off or default. Consumers don't understand what charge off is, but the industry does. So this is basically the point at which the debt was no longer considered an active loan, but it was going off to collection, right? So to give you some information about some point in time, and I'm going to get back to that charge off information in a minute. The amount of the balance, so you have some sense of what they're claiming you owe, and then the amount of the judgment the plaintiff is seeking. Those 2 numbers might be different, right? Because maybe the plaintiff is also seeking attorney's fees, or maybe there have been some charges that have been added on afterwards, court costs and things. So what are they asking for? And then credits or payments are applied. So in other words, if there's some kind of credit that you're getting that they're going to apply, or you've made a payment or something like that after this was charged off, then letting you know about that. Next slide, please. And then this is really important for everybody, but for the courts especially, information about the plaintiff. So what authority do you have to actually be bringing this lawsuit? And part of that, obviously if you're we keep going about the poor landscapers who apparently never get paid, but if you're the landscaping guy who, mowed the lawn and never got paid, and you're suing the person whose lawn you mowed, they probably know who you are, right? But if you are ABC collection company and you're suing somebody, they probably have no idea who you are and no idea why you're related to this debt of theirs. So what we're asking is for the plaintiff to identify the chain of title. So who owned this debt along the way? Where did I get it? When did I get it? So that because basic principle, you have to be the real party in interest in order to sue. You have to have some right to this debt. I just can't say, hey, I know you owe Sears some money, so I'm going to sue you for it. I have to have some right to do it. And then also, some states require licensing to collect debts. So if your state does require that, we also want you to say that you have a license or license number or something. Identify what you got. I think like Texas requires a bond, so you have to say you have the bond or whatever. So if your state requires something, you'd have to show that. Next slide. I can't see these, so then we also want if you're not the original creditor, well, actually, even if you are, but this is more important than not. So we want there to be some evidence that the court can see and you can see as to the fact that there really was a debt. And so some kind of agreement signed by the consumer, and this goes to something David was talking about earlier. A lot of these acts were across the states were written just about credit cards, but no offense to state legislatures here, but they were apparently written by people who didn't understand how credit cards worked in this decade. And so a lot of them required a signed agreement, which if you've ever gotten a credit card recently, they don't exist. They existed when I got my first credit card, but as you can tell by the color from my hair, most of you weren't even alive. And so we're trying to sort of bring this up to the real world. So an agreement signed by the consumer, if there is one, some kind of documentation of a purchase or payment or use of the account, so maybe a credit card statement, right? A bill that shows you charged this thing, an invoice that you didn't pay, or other documentation of the consumer debt. That's sort of a catch-all. Again, going back to what Dave was saying about different asset classes. First of all, new ones are created all the time that we don't think about, but this is sort of catch everything in there. So some kind of evidence that this person actually had this debt. It doesn't have to be 6 different things, but just something so that the court can say, okay, yeah, there really was a debt here. Now, if the plaintiff is not the original creditor, then we go back to documentation of the chain of title. So here we want to see the documents. We want the bill of sale or transfers or assignments or whatever else it is that shows that this person actually has the right to be collecting this debt, has standing to bring this lawsuit. Next slide. So that's all going in the complaint. Additionally, we're requiring this thing called notice of intent to file default judgment. So as the act currently stands, the notice would go out with the complaint, sort of as a big plain language thing saying, look, if you don't do what you're supposed to do, and I'll get to that in a minute, there could be a default judgment entered against you. And we want this thing to be conspicuous. We want the consumer, this is sort of like a second punch. We realize they're getting a summons that tells them to come to court, but if you've ever actually read one, I mean, I had my law students misread them, right? I've had lawyers misread them, right? There's little tiny print, this is like in your face, here's what's going to happen to you if you don't show up. Next slide. So what we're saying in this notice is, okay, if you don't answer or appear, and it'll depend on where you are. So, because one thing that we came upon very early in this process is that these actions are being brought in all different kinds of courts, right? So in standard civil court, you get a complaint, you file an answer, or you're defaulted. Well, in most small claims courts, there is no answer. Your answer is you appear in court, right? And you show up for the hearing, and if you don't show up, there's default. So we wanted this to say, whatever it is you have to do, if you don't do it, a judgment's going to be entered against you automatically. That's going to happen. So not showing up means there will be a judgment. The other thing we want to tell them, which many, many, many consumers don't understand, is if you don't pay this judgment, it continues to get bigger. So yes, you may have owed them $500, but that was 8 years ago. So yeah, you do owe them, $2,000, $3,000, whatever, dollars they're now suing you for. And the last one, again, is something that I can't tell you how many times in my 25 years of practice I've heard consumers say this, that the debt remains due even if it's no longer on your credit report, right? Because it stays on your credit report for 7 years, but in most states, you can collect a judgment longer than 7 years, right? So many consumers say, well, I don't owe this anymore, it's not on my credit report. Well, you still owe it, just because it's not showing up on your credit report. So we wanted that spelled out to the consumer, that just because it's not in your credit report, you may still owe the debt. Next slide. And then we wanted to be very clearly telling them, well, what might happen to you if you don't follow through, right? So there's statements about the effect of a judgment, right? So the things your creditor might be able to do, like garnish your wages, put a lien on your house, put a lien on your other assets, garnish your bank account. And this is going to depend on the state because different states can do different things. But essentially, whatever the state can do is going to be in this notice. That a judgment can make it actually harder for you to get a job or get insurance because of your credit report. That a judgment might make it more expensive for you to get a loan, get a credit card, rent an apartment, buy a house. There was a lot of discussion at our drafting meeting about why are we trying to scare people too much? And my response to that is we want to scare you to death. We want to scare you enough that you will actually show up and do something. So yes, it's going to be really scary, this notice, because we want to scare you. We want you to know what's going to happen if you don't do anything. And then finally, next slide, on that notice, there'll be information about where you might be able to get help. There are legal services programs in every state. And so this will provide, an address or whatever your local, whatever legal services or clinic or whatever that you might be able to go to get help. Unfortunately, we can't tell people they will be able to get help because we all know that there's more people in line than can get help, but at least there'll be some resources, pro bono resources that they could access. Next slide. And then finally, there's a provision in the Act against waiver. So I had a colleague who did a study once very recently of consumer leases, landlord tenant, and found something, and I'm going to misquote her, but it's something between, like 98 and 100% of all leases have illegal provisions in them. Almost every lease I've ever seen has an illegal provision in it. The tenants just don't know it. So we've added a provision in here that says this can't be waived by contract, right? So you can't give someone a loan and then have it as part of the contract that you're waiving the provisions of this act. So the consumer can't in any way waive the provisions of this act by contract with the plaintiff. And that's basically the broad scope of what the act will do if we get it. And as Caitlin mentioned, the act is online. We're going to also provide a copy of it here, but anybody can write in comments or questions or concerns. It's not final yet. It's almost final, but it won't be final until July. So still time. And then the last slide has our contact information if anybody, is so interested that they want to reach out to us.
And I do think that the presentation materials, and hopefully we'll link to some of Hugh's work as well, as a resource on the ABA's website. So following this, if people want to know more or really go into the weeds, you can geek out.
Yeah, and also actually on the Uniform Law Commission website, all of our materials are there. So not just the act, but the comments that people have sent in, some of the research we've collected. So that's all there too, if you really wanted to dig deeper.
Yeah. Well, thank you. Thank you to our panel. I think we got a couple of questions online, but I know the microphone is also available for folks in the room.
Good afternoon. Thank you for this presentation. My name is Christopher Swope. I just had a brief question about if you have found any areas where specific state protections for consumers are greater than what they would be in the Uniform Act, and how the Act addresses those concerns.
I think New York and California both have greater protection. And I say that because they include some things like about notice and things. We deliberately didn't do that because states have very different essentially, we didn't want to impinge on state court rules and processes. And there's also more detail. I think it's Wisconsin or Minnesota has more details about Wisconsin on medical debts. So I think they're the only three, and you guys might say that I know of that go further.
It's a little hard to answer that question just because each state, again, does a little bit of a different nuance. I suspect in the 11, 12 states that have adopted something, you probably point to something that's different or extra. But I think what the Uniform Law Commission has successfully done here is got a core, a strong core of of requirements that if you can prove these core requirements, it you essentially have identified the correct consumer, the correct amount, and that it's the correct plaintiff that's bringing the suit. And that's the most important. And perhaps, I think Judy's right. The states that might have extras might be more, those extras might be more geared to how their court system works. So it's more unique to those states.
And if I do my job, now that I'm retired, in the next 6 weeks to 8 weeks, there will be a chart on the Uniform Law Commission's. I'm trying to like chart out the states that have laws and how they compare with this. So hopefully I'll do my job and you can look for that, but don't look for 6 weeks.
Hi, thanks so much for the presentation. I was struck, I think particularly with Erica's presentation in that in almost everything that was talked about, you could have replaced the consumer debt situation with landlord-tenant cases and housing cases. And I know in that context, there's an ever-growing and quite successful sort of right to counsel in those eviction cases movement that's kind of burgeoning across the country. Wondering if you think there are sort of lessons to be learned from that and maybe arguments to be made as far as thinking about a movement towards right to counsel and these other types of civil cases.
Yes. So I've done debt collection work for years, but actually my specialty is more housing, and I've been very much involved in the eviction process. I think we talked about this in across the board. We wouldn't get this act enacted if we gave a universal right to counsel. That's just the reality of it. But should there be? I mean, civil Gideon to me is the fundamental social justice issue of lawyers. We should have it. We need it. We're not going to do it in this act, but that doesn't mean we should stop trying.
I think I would just add that the availability of counsel is going to be a problem regardless of whether there's a right to counsel. So even if we did have a right to counsel in debt cases and all housing cases, we would never have enough lawyers to provide that right. So what an act like this does that I think is really helpful is create some kind of baseline so that even if people don't have lawyers, the process is more straightforward, which could, if it was complementary to some kind of right to counsel movement, could actually also help make sure that lawyers who are providing these kinds of services are practicing at the top of their license and not helping people navigate through some obscure text, but actually providing the affirmative defense and zealous advocacy that they're looking for.
Hi, thank you so much. I'm curious how your work intersects with coerced debt, because a lot of folks, like Judith, when you were speaking about someone who might not realize the debt is theirs, but what if they were coerced into that debt, by example, an abusive partner? So technically the debt is theirs, but they should not have to pay it because of other reasons. Does the Uniform Act do anything for that, or does any of your work touch that?
Well, it doesn't directly do that, though the act, so essentially this would be under the act, right? Because it's their debt. That would be something that, again, someone would really want to show up and argue, because that would be a whole other defense. It's not, so in the sense that it's under this act, yes. But it doesn't directly deal with, it doesn't create defenses or anything like that, but maybe it encourages people to show up and argue that it's coerced debt.
Actually, I think that could be the next commission for a model act. Yeah, the coerced debt, the first statute to be adopted in the country on coerced debt was Maine in 2019, followed by California in 2022. I have seen probably at least 7 to 10 states introduce bills in 2023 related to coerced debt. And it's not just issues of domestic violence. It could be human trafficking, it could be elder abuse. There are many different types of relationships where you could have someone with diminished capacity or just the relationship, if you will, between the victim and the perpetrator And, RMAI, our position is supportive of those bills that are out there. You know, but I do see that as the new trend. And it's a recent trend, but it is also potentially a trend that does speak for a model act, because the versions that we're seeing introduced are very different in many instances. And again, back to the business community who's trying to implement it, we just don't want 50 different statutes in 50 different states that do things that are kind of similar, but not quite.
Don't see any other questions in the room at the,
Not remembering the little that I did know, how many states take the debts and turn them into criminal? Is that a lot where they turn them into a crime?
Not, no, and yes. So they don't directly turn them into crime. There's a problem with Indiana, unfortunately. We have this problem despite our Supreme Court saying you can't do it. The judgment's issued, and then the person doesn't pay it. So,
Right.
so then they say you committed a crime because you violated a court order,
Right.
right? And then they haul you in. And like I said, there's one county in Indiana where they keep throwing people in jail, and the Supreme Court keeps telling them they can't, and they keep doing it anyway. So I think I don't know of any state where it's directly a crime, but not paying the judgment can become that. That's not constitutional everywhere. It's just getting that. Again, people don't have lawyers, so they don't realize that they get picked up, they end up in court. And unfortunately, again, like I'm citing my own state just because I'm most familiar with it, the judge will set the bond at the amount of the judgment. So they end up having to pay it whether they owed it or not to get out of jail, which always unconstitutional. But it is happening. I don't know if you have any research on that, Eric, or
Well, I'm not familiar of any state where it's a crime to not pay your debt, except for maybe to the government. But I mean, I know that the term debtor's prison is sometimes thrown out there. Usually, if a consumer ends up in jail, it is usually because of a violation of a court action or failure, But I will say that RMAI, we actually have a standard, one of our certification standards makes it very clear to all of our certified companies that they will not seek, they will not promote any type of action by the court that would result in the jailing or imprisonment of a consumer on a collection-related matter, even for failure to comply with a court order. We just don't want any of our companies involved in that whatsoever. So even if it is permitted in a particular state, our companies are basically directed to convince the court otherwise. In other words, don't allow for that to happen.
Which is great because as according to the ACLU, at least a couple of years ago, that is a law on the books in 44 states. So it's not a common practice, but it is a part of a lot of state policy to permit incarceration for not failure to pay, but failure to abide by a court order to pay, which is perhaps a distinction without a difference for most people.
yeah, I mean, and that's I think where it happens. They're brought in they're brought in because they can't pay or because they didn't follow the court order, and then what happens is they're ordered to pay, and sometimes courts don't. So they can't keep you in jail because you're not paying, right? They can put you in jail because you didn't follow the court order, but as Eric pointed out, that's the distinction without a difference because some judges do it anyway.
Okay, so
And it's bad.
I got it, sort of.
Yeah. And you may have followed, Wall Street Journal did a wonderful whole series on Indiana's prison problem with debt collectors.
The other not very good question. I remember in DC that we had people who got their companies that buy things that people own, and they have big piles of them, and they looking for it. And then at least in DC, I don't know if we fixed it yet. they could come in with that without checking on it. And just they'll take it that the people don't even know that. And then they get hit that way. And they don't have, really, they don't even know what's going on. You mentioned that, I think, earlier. And that there is, if I remember right, that Maryland did some law that fixed that. And the number of people who were forced into court was much smaller in Maryland, if I remember that story. Does that make any sense?
I'm not quite sure I'm following you. I know the Maryland, it was a chain of title,
Uh-huh.
right? And that's one of the things we're including in this act, and I think
Okay, well,
all of
then
the
I'm
acts.
sort of half
Yeah.
right.
Yeah, I think it's, I know it's in California, I know it's in New York, not in all of them, but, so the idea being that, you can't, and I've had this happen with clients, right? They're being sued by two different debt collectors on the same debt. Because debt collector A sold it to debt collector B, and apparently in his books, they didn't realize they sold it, you know? So the idea is to prevent that kind of thing from happening, so that the person that is suing, you know, there's proof that they have standing to sue, which,
Yeah. And apparently we didn't fix that in DC unless one of you knows that they
well,
have.
hopefully this will.
Actually, DC passed a new law in 2022. They address.
Oh,
it's a
good.
very sweeping law involving debt.
Good. I'm just out of the,
Yeah.
good. Well, I'm glad to hear that.
I do want to, if we can quickly get to a couple of the online questions that came in. So the first one's a little bit more on the federal side. I'm going to talk really quick and see if we can get these all done. Have you taken into account the impact of Ramirez for purposes of Article 3 standing on suits brought under the FCRA, FDCPA, and TCPA? FDCPA litigation has significantly decreased because of a court decision standing. The comment from
So-
Carla question.
Yeah, well, yes, but we don't have to because, well, first of all, this isn't
That world.
this isn't that world, and
Mhm.
I think there's been confusion about that. This isn't that world. And what this statute would do, the major difference, we're not asking for damages. Can't get damages under, this just says the default judgment can't enter. So this whole idea of having to show economic harm, it hasn't happened yet. The FDCPA, those things are different because you're affirmatively suing and trying to get damages. I don't know if you could comment more on that, but so it's like apples and oranges.
Mhm.
There's no real connection.
I agree.
Yeah.
The next comment/question we have appears to be kind of about click wrap agreements. So I get that there are not written agreements anymore, but there needs to be some sort of recognition that people are clicking on agreements full of all sorts of fees, interest charges, attorney's fees that get added on. The reality is that we know that no one is reading this before signing. So don't we need rules about reasonableness of add-ons when filing collection lawsuits? Comments, reactions?
Again, it's kind of apples and oranges. That's going further than the scope that this act, except that we are asking for some proof of the debt. So if in fact you're in the lawsuit and you're saying I'm entitled to X, Y, and Z fees, you would have to provide some documentation that the person actually agreed to pay X, Y, and Z fees, right? But there's nothing in this act that's trying to directly deal with whether you can have those fees. That's a whole different scope.
Now, the only thing that I would mention that RMAI has a standard on that, that we specifically prohibit the charging of prejudgment interest. So the only time interest for our certified business would be applied would be after they receive a judgment, and they would be entitled to post-judgment.
Okay. I think that's it. If there are no other questions from the room, thank you so much.
I hadn't heard that.
Late breaking news for those who are remote. Divided these days.
Mhm.
Can I tell you what's most interesting about this? So I'm from Indiana. You can't get any redder. You can try. Indiana and Texas, again, not a very blue state, were one of the first early states that now put in rules about this, right? Indiana, it's just court rules. Texas has some rules too, but so in that sense, I have not surprisingly seen that kind of pushback. And interestingly, it's all very personal, right? So for instance, in Indiana, when we were working on trying to get rules, it just so happened that a Republican senator had gotten debt collection calls on a debt he didn't know, and another Republican representative had gotten a wage garnishment on a debt he didn't know.
Yeah.
Put it out.
I think this is really a bipartisan issue. What we're talking about here is fundamentally the integrity of our judiciary and the public trust and confidence in the courts, which really spans across red and blue divide.
Yeah, I agree. And in particular, in 2023, we're seeing a lot of bills at the state level introduced regarding medical debt, student loans, and course debt. And what I will say is that it is definitely bipartisan. You tend to see the bills that involve those three types of debt. If it's a Republican state, they're majority Republican sponsors. If it's a Democratic state, they're majority Democratic sponsors. So that does seem to cross, especially those areas, cross party lines.
I mean,
Yeah.
unfortunately, debt's universal.
Yeah. And if I could make just one final comment, of course, the Uniform Law Commission's work is entirely nonpartisan. Our commissioners come in, I work with all of these individuals. I often don't know what folks' personal political feelings are, which is really refreshing. When it goes to, when it comes to actually enacting these uniform acts, of course, we have to be aware of what the political realities are in a given state legislature. So this kind of harkens back to the earlier comments folks were making in previous talks about sort of messaging and knowing your audience. So our talking points may vary a little bit depending on what particular uniform act we're advocating for, but it's sound policy and it's all bipartisan. Anyway, thank you so much. Thanks to the panel.